Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. If you've ever had a question about your employment law rights, then you've come to the right place. Welcome to Ask a Lawyer. I'm your host, Dana Levinson. Each week, we dive into different employment-related topics that are on many Canadians' minds. I'd like to welcome my guest for today, Lior Sampiru, National Partner of EmploymentLawyer.ca. Before we get to your emails and phone calls, let's get to know more about you, Lior, and your EmploymentLawyer.ca, and why you believe that everyone should know their workplace rights.
Well, Dana, great to be here with you. And as an employment lawyer, I try to solve workplace problems. And the thing about employment law is there's a lot of rights, but employment law can't help you unless you know those rights, unless you give it a chance. And I want to educate people about the rights they didn't even know they had. And I take this opportunity here to inform, to educate, and advise people about what to do if they're facing a workplace problem. It's not always going to be sunshine and roses when it comes to your workplace. You're going to face some obstacles, some difficulties, but what you have to always remember is that the law is on your side. We're going to talk about that, and I hope that people can find that there is a solution that's available to them and there is something they can do.
And we have learned that people do have rights. So we're going to just break that down now. We want to take calls and emails. We certainly want to get to the calls and emails that Lior has been getting over the past week. So what issues have really stood out to you this week?
So I'm facing a lot of questions still with respect to matters arising out of COVID-19 and the impact of that on the workplace. So let me tell you about a situation that came across my desk recently. I spoke with an individual who was off work for a while because of COVID-19 and finally was called back to work. When he was called back to work, though, his employer said, "We're going to need to change your hours of work." Traditionally, he had worked Monday to Friday, kind of standard 9 to 5. Well, his employer said, well, from now on, we're also going to need you to work every other Saturday. Well, for reasons that it may be obvious, it wasn't something he wanted to do, family obligations. It was a very different type of job now. So he called me and he wanted to know, what can I do? What are my rights? So here's the thing. It is a significant change to the terms of employment whenever you're being asked now to work weekends when you weren't working weekends before. It is not something his employer is allowed to do. An employer is not allowed to make significant changes to terms of employment. And anytime an employer does that, this concept, this term of constructive dismissal should come to mind. We'll talk about that later. And if in this situation, he has a choice. He can accept it and continue working and work that weekends that his employer wants him to, or he may be able to treat his employment as being terminated and require his employer to pay him severance. He's decided to do that. I'm going to help him do that. But it's an important reminder there for all our viewers that if your job, whether it's hours of work, days of work, compensation, even responsibilities, are changed in a significant way, this concept of constructive dismissal may provide you with certain rights.
Yes, and it's misleading because when people hear the word constructive dismissal, they don't necessarily understand what that means. But I know you're going to tell us all about it. So if you want to get in touch with Lior and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. Let's kick things off by taking our first call, Lior. These calls come to us from your radio shows across Ontario, where you take questions live from listeners about their employment law issues. Take a listen.
I've been employed for a company for 18 years. Today, they tell me due to restructuring, they no longer need me. Director of operations, grew the business, and they offered me 18 weeks.
18 weeks? Wow. How old are you?
48.
Well,
Wow.
You know, it's something that people will face. You've worked for a long time. You think everything is fine. And all of a sudden, that rug gets pulled from under you. The thing is, from a legal standpoint, your employer is allowed to let you go pretty much for any reason as long as they pay you proper severance. So for this person, the question is that 18 weeks that he was offered, is that enough? I can tell you that it's not, but here's how anyone can find out on their own how much severance they're owed or whether their severance offer is appropriate. All you do is you go to PocketEmploymentLawyer.ca. You'll see our severance calculator tool there. As the name suggests, it helps you determine how much severance you are owed. Free and anonymous. You should always check it out as the first place if you lose your job. Now that we know that, let's take it and apply it to this individual.
Okay.
We know that he's 48 years old. He's worked for the company for 18 years. He was offered 18-week severance. As you see on the screen, based on his rights, he could be owed as much as 24 months of severance, anywhere from 18 to 24 months. You don't need to be a mathematician to understand that that's a significant difference. That's why he's owed. That's why he has been wrongfully dismissed. And you at home, if you're let go, you should do the same thing. Make sure you go to Employment Lawyer or to PocketEmploymentLawyer.ca and calculate your own severance.
And so many times when people are dismissed, they just take the word of their employer. This is your severance package, and out you go. And they're just grateful for the money at that time. And, you know, it's such a whirlwind when you're losing your position.
Well, individuals assume, well, if my employer is offering me this, they must know.
Exactly.
Well, the reality is, I can tell you, I've done this for a long time. Over 90% of people, when they are let go, are offered significantly less than what they're owed. So chances are, if you're staring at that severance package, I can tell you without even seeing it, it's extremely likely that it's inadequate. You're probably owed a lot more, and you should never sign it. Once you sign it, by the way, Dana, and you realize the next day you made a mistake, you can't go back. You have to get it right the first time.
Okay, this is turning out to be a fantastic show. Let's take a short break. When we come back, we will speak with employment lawyer Lior Samfiuro. Stay with us. And once again, EmploymentLawyer.ca. Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. Welcome back to Ask a Lawyer. Employment lawyer Lior Samfiuro from EmploymentLawyer.ca is answering questions about your workplace rights. If you want to get in touch with Lior and his team, you can call 1-888-861-4555. Email ask@employmentlawyer.ca or visit their website, employmentlawyer.ca. Before we get to our next call, Lior, can you break down 5 myths of termination of employment? Because this is big, right? There's so many myths out there, but there's really the 5 top ones. And the first one that we talk about generally is you have to work for 5 years for a large company to even get severance.
We talked before the break about the fact that you can't accept inadequate severance. And the reason it does happen every day, people accept that severance, is because there's all these misconceptions. People believe certain things about it, so they don't know better, they accept inadequate packages. And the first myth, the first misconception, as you've outlined, is that you have to work a certain minimum amount of time before you get severance. Wrong, wrong, wrong. Every employee gets severance. If you lost your job, you had a job, you are owed severance, whether you work for a month or 25 years. There's no 5-year threshold. I'll go a step further and I'll say that short service employees are actually treated disproportionately better than longer service employees. So you may have only worked for, say, 6 months. You could be owed 4, 5, even 6 months of severance. Really? And that's a significant amount. So no, please, if you had your job and you lost your job, you are owed severance. And by the way, it's probably a lot more than you realize.
Okay, let's get to myth number 2. You only get 1 or 2 weeks pay for every year of service when you're let go.
And that is the big one. There is this huge misconception. Well, severance is a week, maybe 2 weeks per year of service. Wrong, wrong, wrong. No, it's not that simple. In fact, for most people, you're owed significantly more than that. The main factors, and I think you know this, that go into severance are your age, your position, and the length of your employment. And that severance usually is going to be measured in months, not weeks. You could get as much as 24 months severance. So please, forget about this idea of a week per year. It's not even close. It's much, much more than that.
Where do you think that comes from?
Well, unfortunately, the Ministry of Labor that administers the Employment Standards Act advises individuals with respect to their minimum entitlements, which is, in fact, a week per year of service. But those are only your minimum. Your full entitlements are much more than that. So if you go on Google and you Google your entitlements, you may come across, well, it's a week per year. But that's only a small portion of what you're actually owed. That's why we created EmploymentLawyer.ca to allow you to calculate your full severance amounts.
Interesting. Very good point. Okay, number 3. If you were fired for doing something wrong, you don't get severance.
The only time you get deprived of severance is if you've committed such a serious offense that it's impossible to continue employing you. We call that the termination for cause, and it's the capital punishment of the employment relationship, and that it's only reserved for the worst offenders. So you may have done something wrong. Maybe you've even done a few things wrong. That does not mean you get deprived of severance. Listen, if you were late 3 times this week, that's not a good thing, don't get me wrong. But that doesn't mean you can be let go without severance. I've seen so many cases where people are let go without compensation, without severance, because their employer pulled the trigger before they should. That's a wrongful dismissal. So the bottom line is, doing something wrong does not mean no severance.
Okay, number 4. We talked about this. Short service employees get very little severance.
Well, so many times you may work for a few months and you think, well, you know, they let me go. Maybe I'm owed a week, maybe 2 weeks. I'm not even going to bother looking into this. As I said before, that's not the case. Your severance is still going to be measured usually in months. For most people, that severance could be a minimum of 2 months going up from there. So whether you work for a month, 6 months, or any other period of time, you still have to get that advice. That severance that you're owed is going to surprise you, even if you're a short service employee.
Certainly will surprise you if you think you're getting nothing. Okay, number 5. If you push your employer for a full severance package, you're going to burn bridges. That's a big one.
It is a good one, and it's a reason why some people may not contact someone like myself for legal advice. Here's what I say. First of all, you should never feel bad for pursuing what the law says you should have. Keep in mind, I don't have the ability to get someone even $1 more than what they're legally owed. So if all you're trying to do is pursue what the law says you should have, don't feel bad about it, don't be afraid about it. That all said, in the vast majority of cases, we don't burn any bridges. I'm very mindful of that. So we would want to resolve matters quickly and amicably and professionally with your employer. In most cases, that's not a difficult thing to do. So people should not be afraid of that when it comes to pursuing their legal rights.
Okay. Such great information, Lior. I want to get to more of your questions. So here's another caller from your radio show. Take a listen.
I have been working for the same employer for the last 26 years without a contract. Recently, he has handed me a contract, which he is telling me I need to sign at this point. So I have already decided I'm not signing that contract. And in the meantime, they have started to make my life difficult, making my job difficult, excluding me from different things.
Is it common practice for people to be hired and not have a written contract?
So these days, it's not so common because employers start to understand that a contract of employment benefits the employer. But if you're someone that has not signed an employment agreement, you're working kind of on a handshake deal, consider yourself fortunate. An employment agreement is not something that an employee should want. Not having an employment agreement means you have the full protection of the law. You have all the legal rights that the law provides for you. An employment agreement often takes away those rights. You have rights, but you can also have the ability to give them away. And employers are understanding that. For example, an employment agreement could limit your future severance significantly. An employment agreement can give the company the right to change your job or hours, which they don't otherwise have the ability to do. Can impose non-compete obligations and other things as well. So if you're already working and your employer wants you to sign a new employment agreement, be very concerned. It's not good news, okay?
And this caller, she had mentioned she wasn't treated very well.
Well, because her employer really wants her to sign that agreement. Definitely, I would tell her to document how she's not being treated well. That mistreatment could be a constructive dismissal by making her life difficult. But bottom line, without understanding what she is signing, she should not sign it. Same with our viewers right now. If your employer wants you to sign a new agreement, let me see it. Let me tell you what it actually means and what it does. Once you sign it, it's difficult to go back. Generally speaking, if you're haven't signed an agreement before, now you're being asked to sign one, that's not good news.
Okay, let's take a short break. When we come back, Lior from EmploymentLawyer.ca will answer an email question from Abdul about severance for independent contractors. Stay with us. Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. Welcome back to Ask a Lawyer. Lior Safuru from EmploymentLawyer.ca is taking your employment law questions. If you'd like to get in touch with Lior and his team, you can call 1-888-861-4555 or email ask@employmentlawyer.ca or visit their website, employmentlawyer.ca. We still have lots more to discuss. Here's another question that came in.
I was let go on Thursday without reason. They just said, we're going to have to let you go. They did give me a release form to sign. They're offering me the Standard Acts, which is, I think, the 2 weeks. I was doing customer service for 3 years. I am 47 years old.
Can we use the severance calculator here?
I think we need to, and I can tell you that this is one of the most common types of questions that I get at the office. Someone was let go, and they want to understand whether what they've been offered is appropriate. So here's the thing. Let's plug her information into our severance calculator, which, by the way, you can find at pocketemploymentlawyer.ca, and let's see what she's actually owed. So we know she's 47. She's been there for 3 years, offered 2 weeks. We can see at the bottom that the real amount in terms of what she's owed is about 3 months.
Wow.
And I can tell you, Dana, that's actually conservative. It could be closer to 5 months, actually.
Really?
So anywhere from 3 to 5 months is what she's owed. So that's why it's so important to go to pocketemploymentlawyer.ca. I mentioned it's free, it's anonymous. You don't have to put in your name, your company's name. It's just there for your information. And it's the first place you should always go to if you lost your job or worried about losing your job. Or maybe you're just interested and curious to know, hey, what would I be owed if it ever happened that I did lose my job?
Know what your rights are and your severance pay. Okay, we have an email question from Abdul. The company I work for just told me they no longer require my services. I'm pretty sure I don't get any severance pay because I was employed as an independent contractor. But my son doesn't agree. Who's right?
Well, I feel like I'm taking my jacket off and getting up on my soapbox a bit here, because this is a topic we're going to cover more in future shows. It's an important one, and that is being misconstrued or misappropriated as an independent contractor when you're really an employee. That happens often, very common situation where someone is misclassified. If you have a regular job, you are an employee. It doesn't matter what you call yourself. It doesn't matter what the company calls you. It doesn't matter how you pay your taxes. If you look like an employee and you act like an employee, you are an employee. And that's important, because if in the law, in the eyes of the law, you are an employee, well, you're owed things like overtime and vacation pay and holiday pay, and of course severance if you lose your job. Many times independent contractors, quote unquote, are let go. They're not paid any severance because everyone assumes they're independent contractors. But if they've been misclassified and they're employees, guess what? They are owed severance like any other employee. Now, I mentioned pocketemploymentlawyer.ca. We have a tool there that also allows you to find out if you're an independent contractor or an employee. You answer a few questions, and it's going to tell you, employee or contractor. Very, very common. If you're watching right now and you're not sure what you are, chances are you are an employee.
Great resource. Thank you, Lior. Okay, let's take one last break. We'll have more with Lior from EmploymentLawyer.ca in 2 minutes. Stick around. Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. Welcome back to Ask a Lawyer. Leor Samfiru from EmploymentLawyer.ca is answering your employment law questions. We have time to answer a few more. So here's an email from Caitlin. I've been off on mat leave for the last year. I've tried to contact my boss about my return in 2 weeks, but she's not getting back to me. I'm getting concerned because they just hired somebody to do my job. Leor.
Listen, when it comes to maternity leave, parental leave, it's not complicated. You have a right to the same job at the same pay in the same way that you did it before your maternity leave. And there's really no exceptions to that. So if your boss doesn't take you back or gives you a different job, that's potentially a human rights violation. It could be a violation of the Employment Standards Act. It could be a constructive dismissal. It's wrong and it's illegal. So in this situation, if in fact, when it's time to go back, if her job is not there for her or if she's offered a different job, there's all kinds of consequences for that employer. You really don't want to be on that end of it if you're an employer. If you have an employee that's taking off a parental leave, regardless of how long he or she is taking that leave for, you don't do anything. It's okay to have someone else do the job while they're away. But when that employee is ready to come back to work, they get the job back, no exceptions. Again, if you ever find yourself in that situation, you give me a call because the law does not take kindly to an employer that violates those rights.
Okay, let's take our last question today. It comes from Garth. My work had to close for a few weeks and all staff were laid off. The company is back up and running now, but they still haven't called me back to work. What does that mean for me?
Well, for Garth, even before the company was ready to bring him back, that layoff could have been considered a termination. Your employer doesn't have a right to put you on a temporary layoff. It could be treated as a termination. But now, if he's not called back to work, he can get his severance right now. He doesn't have to wait at home and hope that the company calls him. He can choose to say, now I've been terminated, now severance has to be paid, keeping in mind that severance can be as much as 24 months' pay.
Wow. Leor, thank you so much for being here today. You can catch legal experts from EmploymentLawyer.ca on Ask a Lawyer every Wednesday on CP24. For more information on this show and EmploymentLawyer.ca, visit cp24.com/Ask a Lawyer. Join us again next week as we discuss the difference between independent contractors and employees. Thanks for watching. Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/Ask a Lawyer and watch Wednesdays at 9:30 p.m. on CP24.